Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Good afternoon, Your Honor. Daniel steps up, and right away the judge wastes no time laying it all out. Daniel is facing a serious charge, resisting and obstructing a police officer. That's not some traffic ticket you laugh off. That's a high court misdemeanor, and yes, punishable by up to 2 years in jail and a $2,000 fine. But here's the kicker. Daniel thinks he's clever. He's representing himself, no lawyer, no backup, just him, his knowledge of the law, and apparently a stick of gum in his mouth. Now the judge is crystal clear. Sir, you're going to be treated like a real attorney. I won't help you. I won't explain things for you. You play lawyer, you live with the consequences. And yet, Daniel nods along like he's got this all figured out. Folks, let me tell you, this is where the train wreck begins.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the record. I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Gu, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying. because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We could try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
The judge is trying to keep this professional, but you can feel it, the tension in the room. Because here's a man standing in front of the court on a serious charge, and he looks like he's strolling into a convenience store. Chewing gum, no attorney, acting smug. And trust me, this isn't the first time Daniel's pulled this routine. If you caught part 1 of this saga, you already know this guy refuses to cooperate, refuses to take things seriously and honestly, comes off like one of those I know the law better than the judge types. So today, Judge Simpson is about to give Daniel a reality check. But the real question is, will Daniel listen, or is he about to dig himself even deeper? The judge lays it out, no nonsense. All right, what are we doing with this case? Daniel pipes up, stumbling over his words. He wants a preliminary examination. Basically, he's saying, let's hear the evidence. Now here's where it gets messy. The prosecutor reminds the judge, Your Honor, Daniel filed some paperwork with the Court of Appeals, a writ of mandamus. That's a fancy way of saying Daniel tried to argue that the prosecution was hiding evidence. The appeals court? They tossed it out, but Daniel is still clinging to this idea like it's his golden ticket. He insists the state hasn't given him exculpatory evidence, proof that he's innocent. Except, that's not how this works. The prosecutor flat out says, we've handed everything over. Discovery's complete. He's just confused. And the judge? He's losing patience. He looks at Daniel and says in plain English, what you just said makes no sense. Discovery is complete. We're moving on. But Daniel, oh no, he's not backing down. He tries to respin his words, apologizes for how he phrased it, then circles right back around, still trying to argue the state hasn't shown he did anything wrong. The irony? That's not how trials work. You don't get handed a file that says, congratulations, you're innocent. No, the prosecution brings their evidence to court, and then you defend yourself. Daniel's acting like the state owes him a get-out-of-jail-free card in advance. So the judge sets the date. Preliminary hearing, January 2nd at noon. And he makes it clear. That's when Daniel can argue his motion. Until then, this case is moving forward. And here's the thing. Daniel doesn't even realize how bad he looks. No lawyer, no strategy. Just him talking in circles, making the judge and prosecutor look at each other like, is this guy serious? This is a textbook example of why you never represent yourself, especially when the charge is this serious. But Daniel isn't just clueless, he's smug. He thinks he's gaming the system when in reality, he's setting himself up for disaster. And that's when this case takes an even darker turn.